This video is brought to you by Straight Goods News, Canada's alternative online news source. Visit straightgoods.ca.
Earlier this month, I announced that the Council of Canadians was launching a campaign to invite Canadians to let us know what dirty tricks had been played on them during the May 2011 federal election, and to advise them of legal rights they have as an elector. Sadly, for Canadian democracy, hundreds of Canadians responded to our invitation with stories of fraud, harassment, and other voter suppression techniques. 8 Canadians have courageously stepped forward to tell their stories in the court in 7 ridings. Council of Canadians is announcing today that it is supporting these Canadians who have applied to the court under the Canada Elections Act to annul the 2011 election results in these ridings: Don Valley East, Elmwood Transcona, Nipissing Timiskaming, Saskatoon Rosetown Bigger, Vancouver Island North, Winnipeg South Centre, and Yukon. The Council has selected these ridings because electors came forward and because the margin of victory in each was relatively small. Thus, there's a reasonable basis to believe that the irregularities have affected the results. We have some good evidence about the effectiveness of providing misleading or harassing information by robocalls, and believe it is sufficient in these ridings to convince a judge to annul the results. We have academic research which indicates that voter suppression techniques can reduce voter turnout by 3%, which is roughly 2,500 voters in a normal ride.
What happened was that shortly before the election, I received a telephone call, which was an automated call with a pre-recorded message. The voice was claiming to be from Elections Canada. I remember quite clearly that it said that due to higher than expected voter turnout, my polling place had been changed. I was confused about the call, and I ended up voting in the advance poll just because I felt that I knew where to go for that. A few weeks ago, I heard about the inquiry in Guelph, and I realized that the call I had received was fraudulent. Earlier in the campaign, I indicated that I would not be voting for the Conservative Party. Given what I have heard in the media and my experience, I believe that these calls were connected. I am someone who takes my civic responsibility very seriously. I was astounded to discover that these tactics have been used to such a wide extent and that it has affected the outcome in my riding and potentially others. In Nipissing Timiskaming, the Liberal incumbent lost by only 18 votes to someone who had never run at the federal level before. And that's why I decided to become an applicant in this case.
This is not the end of the robocalls affair. As I've said before, the victims here are individual electors. We believe that through these court actions, all Canadians will be able to find out exactly what happened and who was responsible. Being able to participate in elections is at the very heart of our democracy. It's a fundamental right enjoyed by every Canadian, and it's protected by law. And the Council is committed to fighting to preserve that basic democratic principle. We continue to invite Canadians to share their experiences with us, as well as with Elections Canada. There is a common theme, and the common theme is robocalls either on Election Day or slightly before Election Day, which indicate they're from Elections Canada and indicate that the polling location has changed. Most of the applicants also previously had received calls asking if they would be voting for the Conservative Party or not, and most indicated they would not be. There is one applicant who did not receive such an earlier call, although she said her partner may have received it on her cell phone. But she received the information that the polling location had changed, and as a consequence, she did not exercise her vote because the new polling station, she was told, was well away from where she lived, and she has no vehicle, and so she didn't vote.
All of the applications were filed in the federal court. We will be writing to the court to ask the court to manage the cases together. And then with the benefit of case management, which we hope the court will agree is appropriate in the circumstances, we'll set out a timetable for proceeding with the cases.
And the basis on which you are... So, first of all, they are different cases, but you're hoping to get them grouped as one case?
They're all separate cases, and they're filed pursuant to Section 524 of the Canada Elections Act, which empowers an elector to contest the outcome of an election in their respective ridings. So they're separate applications brought on behalf of individual electors who are entitled to vote in those ridings. But the fact situation in the cases is quite similar, and the evidence will be similar in some respects, certainly the expert evidence we have. So in our view, our request of the court will be based on the fact that there are these common elements, and it would be efficient to manage them together in some fashion. Focus, or narrowing, if you want to describe it that way, was to canvass people about the types of activity that have been reported in the media, which were to be in receipt of a call of one type or another, either harassing the elector during the election campaign with the intent of discouraging an elector to vote for a particular candidate, or a call that misdirected the elector on that day, on election day or before election day, so that they actually wouldn't vote. So one type of voter suppression activity or the other, the kinds of activities that have now been reported in the media for the last month. So that was the focus of the questions we put to people.
All have misdirection as a common theme. There could be some sort of harassment as well.
I'll turn it over to Garry.
I believe all the applicants received calls misdirecting them. We will have some additional evidence in some of the ridings that alleges the harassing phone calls technique. For example, one voter that I spoke with, a mother of a very young child, who had indicated she would not be supporting the Conservative Party, received calls allegedly from the local Liberal candidate as early as 6 a.m. on a Sunday and as late as 11:30 p.m. on a weeknight. And she received about 15 of these over the course of the last few weeks of the campaign. She got so angry she called the local Liberal candidate, and their office assured her that no such calls were being made. So some of the affidavit evidence we will have, I think, will cover some of the other techniques, but each of the applicants received one of the misdirections.
If this remedy is going to have any utility, it has to be provided reasonably quickly. To show who is responsible. We just have to demonstrate what it was that happened. And from a legal point of view, we're indifferent as to the culprit. What matters is that people's democratic franchise may have been taken from them, and they have the right to have it restored, whoever took it from them. Well, we have expert evidence on the impact of voter suppression techniques and what that means in terms of whether people turn up at the poll or not. So we'll rely on that expert evidence, because in a riding where there's a margin of 300 or 800, we're not going to be able to find 800 people, and probably they're going to be pretty reluctant to come forward and say, well, I was fooled and deceived and didn't vote as a result. So there has to be another way for the court to kind of weigh the evidence that will give a judge confidence so they can go from this evidence about voter suppression activity in the riding to an informed estimate of what impact. This is a case unlike any other that we've been able to find reported in the jurisprudence. Federal court. The next stop is with the Supreme Court of Canada, so you don't go to the Court of Appeal, which is an unusual process. And I think it speaks of Parliament's intent to have these issues resolved quickly, because, as I indicated earlier, if the remedy is to have any utility, it can't come 3 years later, 3 years after the election. So hopefully it'll be dealt with expeditiously by the courts. That will certainly be our request of the court.
The riding of Guelph, we looked at the riding of Guelph. We had people who came forward in the riding of Guelph, and we considered that. The problem there is 7,000 vote margin, when our academic evidence indicates that it can have roughly 3% impact. That's roughly 2,500 votes in a riding. So it would be pretty difficult for us, we think, to support an action in a riding where there was such a margin of victory, 7,000 votes.
No ridings in which there was a narrow margin of victory for a Liberal or an NDPer, and there were irregularities.
We received several calls, or we received and spoke with people in several ridings that had that profile. But in the final analysis, we had to make a judgment about what we thought was credible evidence from individuals, whether we have supporting evidence from that particular riding that will come forward, and that was the basis on which we made our decisions. It was really an honest assessment.
And you say we had to make an assessment of it. You were saying that it was.
Well, there were some,
testimony?
one person I spoke to said, well, I know this happened to me. Well, tell me more. Well, I'm not sure what day it was. And they said they were Elections Canada, but, I suffer from migraine headaches. And we just had to make, obviously, some sort of assessment about who we thought were credible individuals coming forward with a story to tell. And that was part of what we did and followed up. And each of the applicants, each of the people who will be putting an affidavit in, a number of people have now spoken with them.